Start. Having heard the learned counsel for the parties, in our opinion, the appeal should be allowed, full stop. Certain facts are not in dispute, full stop. The father of the applicant who was in service, died in harness in March, 1987, and for the first time, the application was made by the applicant after more than 4 years, that is, in September, 1991, full stop. The family thus survived for more than 4 years after the death of applicant's father, full stop. Even at that time, the applicant, under the relevant guidelines, could not have been appointed and hence relaxation was prayed, full stop. It is no doubt true that the case of the applicant was favorably considered by the departments and recommendation was made, but it has also come on record that in March, 1996, a decision was taken by the authorities not to give appointment to the applicant on compassionate ground, full stop. From the affidavit in reply filed by the authorities in the High Court, as also from the finding of the learned single judge, it is clear that the applicant had knowledge about rejection of his application in 1996 itself, full stop. Nothing was done by the applicant against the decision, full stop. Considerable period elapsed and only in 1999, when there was some interdepartmental communication and administrative officer informed the chief engineer via a letter dated 8th June, 1999, that the applicant could not be appointed on compassionate ground, that the applicant woke up and filed a writ petition in the High Court, full stop, para. It is also pertinent to note that the letter of 1999 itself recites that the case of the applicant for compassionate appointment was considered and the prayer had already been turned down by the administrative department, and the said fact had been communicated to that office of the chief engineer, full stop. A copy of the said letter was also annexed to the letter of 1999, full stop. In our opinion, the learned single judge was right in dismissing the petition on the ground of delay and laches by holding that the applicant had not done anything for a considerable period after March, 1996, when his claim was rejected, even though he was informed about the decision and was very much aware of it, full stop. The division bench, in our view, was not justified in setting aside the said order and in directing the authorities to consider the case of the applicant for compassionate appointment and by giving directions to give other benefits, full stop. We may also observe that when the division bench of the High Court was considering the case of the applicant holding that he had sought compassion, the bench ought to have considered the large issue as well, and it is that such an appointment is an exception to the general rule, full stop. Normally, an employment in government or other public sectors should be open to all eligible candidates who can come forward to apply and compete with each other, full stop. It is in consonance with Article 14 of the Constitution, full stop. On the basis of competitive merits, an appointment should be made to public office, full stop, over.